The election looks set to head to the Supreme Court, or does it? Have we seen this before in the year 2000? Welcome to Liberty Nation's LNTV. I'm Mark Angelides. Joining us today to discuss the issue is Liberty Nation's Legal Affairs Editor, Mr. Scott DeCrescenzo. Welcome, Scott.
Hi, Mark.
Scott, give us a brief overview. What's happening here? Is it similar to what happened in the year 2000? Is it something new? What's happening with the election?
Is it deja vu all over again?
Just once more, yes.
In 2000, in the Bush versus Gore contest, George Bush won Florida very narrowly. And it was so narrow, in fact, that the Gore campaign demanded and sought and was awarded recounts in several areas. At the same time, there was a contest going on at the U.S. Supreme Court with both sides asking the Supreme Court to issue rulings that would favor them. In the end, the Supreme Court did rule, and they ruled that the ongoing recounts that were underway in heavily Democratic counties had to stop. And because of that, that meant that the previous count had to be certified as Florida's electoral count, which gave the state, which by I think 537 votes to 37. George W. Bush, and he became president. So here we have a little bit of a different case where there's been election anomalies reported in a number of states, and depending on the math and what Arizona does, it's unlikely that any one particular state would put Donald Trump over the top.
From what I'm reading, Scott, with the latest lawsuit filed for Pennsylvania, is that they're looking to make an equality, let's call it an equality of outcomes in how the votes are treated. Does that make sense?
I think it's better to say the 14th Amendment's guarantee of equal protection is what they're seeking to have enforced against the states. And what they've said, tracking back now to the Bush versus Gore legislation, that's the first time we've seen that kind of contest in the Supreme Court. So that's the only precedent that we sort of have to go on with the presidential race. But in heavily Democratic counties, they were doing this quote unquote recount or examination of votes that weren't properly recorded. But that similar type of examination was not occurring in pro-Bush counties. So therefore, they were saying that you can't do that for one and not the other. All the votes have to be treated the same. And so that's why they stopped the count and said, go ahead and forward and publish the results for the votes that have been treated the same.
I believe what's happening now, Scott, is that one of the issues that's been brought up in the case is about vote curing.
So the Trump campaign has said that votes in Pennsylvania have not been treated the same. There are a number of ways they allege that has taken place. One of those ways is, Mark, that voters in Trump or heavily Republican jurisdictions, if they cast a vote that was, they improperly cast, for instance, a mail-in vote. They didn't use the security envelope like they're required to do by law, or their signature, there was some deficiency. In the Trump counties, generally, those votes were just tossed aside. They didn't legally cast a vote, and so they were tossed aside. But in the heavy Democrat counties, in Philadelphia and Allegheny counties especially, the suit alleges that those voters were given an attempt to cure their deficient ballot. That's the current federal lawsuit that the Trump administration filed on the 9th in the Middle District of Pennsylvania.
So after reading this, Scott, not so much a personal opinion, if you will, but more a professional opinion as a lawyer who's licensed to practice it in Pennsylvania, I believe. Do you think that the case that they're bringing forward here, is it spurious? Does it have actual meat on the bones?
Right. I can tell you without hesitation that emergency election litigation was not covered on the Pennsylvania bar exam. That's the one thing I'm confident of. I would say to you
should have been.
I have read the complaint, and it does not read like some pie in the sky, fantastic assertion. The evidence is presented with affidavits, and when somebody swears to something and testifies to an improper or illegal act, that is in of itself evidence of that thing. And so
sorry, Scott, this is something I want to just very briefly jump into. I'm seeing a lot of reports in the media saying things are being presented without evidence. Now, it's factually and linguistically and legally correct to say that affidavits are evidence. Is that right?
Testimonial evidence, 100%. I mean, it's not a small thing for somebody to submit sworn testimony in an affidavit.
Thanks for shedding light on the topic, Scott. Thanks for being here.
Thanks, Mark.
And thanks to you at home.
Go deeper on the topic discussed in this video, head on over to one of these links here or go to our Liberty Nation Roku channel. Thanks so much for watching, and don't forget to subscribe and hit the notification bell for Liberty.